In August of 1968, during a New York State family court-ordered placement to ECMC Psychiatric Ward for observation, I was subjected to a salvo of sadistic pseudo-analytical torture and sexual molestation under hypnosis by an Episcopalian chaplain therapist, Lawrence B. Hardy. Hardy wrote in my medical records, quote, "Talked to patient's mother's attorney, a Mr. Musara, who seemed like a pretty good fellow and was willing to go along with our treatment plan," unquote. Arthur F. Musara, Esquire, was introduced to my mother's family in 1953 by my Uncle Samuel Pizzino, who served in southern Italy during World War II. Musara was also the lawyer for Local 210, the mob-dominated union mentioned earlier, managed by Ron Fino. As shown by letter of July 1965, signed by Musara, provided to me by my mother along with other evidence, Musara drew reciprocal wills and waivers for my parents under the decedent estate law of New York State, waiving their rights against each other's estate in favor of me, just prior to my father's release from the Canandaigua VA hospital in 1966. The fact there were separate estates and not marital property means there was no legal marriage in effect. Since my father was declared an incompetent person in 1960 by County Court Justice William J. Regan, those were fraudulent instruments used to divest my father of his funds, an investment of U.S. savings bonds derived from his VA disability funds since 1945, valued at $1 million in 1972. Musara's deceit is evidenced by the fact he should have known my father was declared incompetent at the time in 1965, since it was his client, my mother, who had petitioned for such declaration of incompetency 5 years earlier. The VA rating system of 100% disability was not a declaration of incompetence and would not have precluded the signing of the will and estate waiver by my father at that time in 1965. Those reciprocal wills, as indicated by Surrogate Court Registration Card 70602, maintained by the Erie County Surrogate Court, were filed on October 15, 1965, under my mother's name and removed by Charles D. Wallace, Esquire, on May 1, 1972. The Surrogate Court to this day refused to allow for the discovery of those 1965 wills in violation of Surrogate Court Procedure Act Section 2507 and Penal Law Section 190.30, concealment of a will. My father passed away in 1992. See July 1965 letter by Musara linked below. The 1040 individual tax returns for my parents, left by my mother, show that from 1956 to 1971, no Social Security number was used for my father. However, from 1973 through 1976, my Social Security number is substituted for my father's. 1972 is missing. See link below for a copy of the 71 and 73 1040s. Pictures of my mother taken in front of Harrah's Casino in Las Vegas in 1972 show her with our cousin Philip Cheech Napoli, who moved to San Francisco, California in 1960, who had Western New York ties to Magadino's henchmen. Pictured alongside Buffalo construction magnate Bucky Simonelli. I'd bet it all that under the shrewd esoteric eye of the Hughes Magadino co-dominion, those 1 million greenbacks of my father's VA disability funds invested in U.S. savings bonds since 45 got lost in the wash in 72. See link below for a picture of my mother doing the laundry in Las Vegas in 72. My uncle Joseph Pizzino, a soldier for the Buffalo La Cosa Nostra, had second endorsed my forged signature on a piece of the rock meant for me, negotiated at the M&T Bank University branch office, along with other evidence. It is alleged that my father's U.S. savings bonds were negotiated exactly the same way in 1972, the icing on the cake. See copy of forged prudential check linked below. Those million clams were then allegedly invested into Samuel's Grand Manor in 1978 under the guise of proceeds of the sale of Wallace Transport, a trucking company where my Uncle Sam attained ownership. In a March 17, 1988 letter from the Department of Treasury in response to a subpoena issued by my father's attorney, David C. Laub, it states, quote, "A search of the department's registration records from 1941 through 1979 disclosed the issuance of several bonds, all of which were redeemed more than 10 years ago, with the exception of 32 bonds registered in the name of Mamie Iannaccone, with Gary Iannaccone named as co-owner, which were retired by this office as undeliverable and are presently being reissued to Gary Iannaccone. Gary is my middle name. See link to this March 17, 1988 letter below. The first Erie County surrogate, William J. Regan, an appointee of New York Governor Nelson Rockefeller, presided over my mother's estate in 1978. Regan, as county judge, mentioned earlier, who declared my father incompetent in 1960 and failed to appoint a committee then, failed to do so again in 79 to protect my father's interest in my mother's estate. The second surrogate, John J. Honan, mentioned earlier, who as DA in 67 reportedly got Calabrese to sing, presided over a 1981 settlement decree that was made prior to discovery and full accounting made of my mother's estate. The decree was made without my knowledge and later reopened to include my father's interests. My father was not mentioned in my mother's 72 and 74 wills drawn by Charles D. Wallace, Esquire, who removed the 65 reciprocal wills as described earlier. Wallace exclaimed he did not know my father was alive after being grilled by Joseph S. Mattina, the third surrogate presiding over my mother's estate. Surrogate Joseph S. Mattina appointed Horace A. Joya, Esquire, a non-family member, as my father's committee in June of 1984. Mattina failed to heed my father's family's demands to have a family member appointed committee, even during a joint investigation into the operation of the surrogate's court conducted by the Erie County DA that included Richard D. Kaufman, then Assistant DA, and the New York State Attorney General's office that took place from 1985 to 1989 involving incompetence estates. Mattina stated in the record he'd only consider appointing a family member after the trial of Marie Law, my maternal aunt, as former executrix of my mother's estate that began in June 1988. My elder paternal cousin, Eleanor Iannaccone, and I were appointed successor co-committee by order of surrogate Joseph S. Mattina, acting Supreme Court Justice on October 20th, 1989, Incompetency File 27466. 4 days before my father died, on April 20th, 1992, I was informed by SSA that he was entitled to Medicare and widower's benefits, and that an application was filed for him in November of 1976 at age 65. The SSA manager had misinformed me in writing back on January 25th, 1984, that no benefits were being paid on his account. SSA failed to mention my father was entitled to benefits on my mother's earnings record, who worked at Tricle since 1948, and she passed away in 1978. It was back in January of 1985, my Aunt Marie Law, as former executrix, was deposed by David C. Laub, Esquire, representing my father's interests. Law was asked if she knew about any SSA payments made for my father or mother. Law said she did not. At that time, in '85, the SSA funds owed to my father from 1976 was approximately $30,000. It's very unfortunate Laub didn't have the common decency to make an inquiry to the SSA for my father in '85 to obtain those benefits and, most importantly, Medicare coverage. My father was understandably terrified of the VA and refused to go to the Buffalo, New York VA Medical Center. See Marie Law's relevant deposition pages at the link below. What's also interesting is back when my aunt filed my mother's death certificate, she entered my son's social security number in place of my mother's and claimed she didn't know her mother's maiden name was Napoli, later corrected by me. See both copies linked below. On March 8th, 1985, my best friend, Thomas F. Martin III, was executed. In October of 1985, my uncle Joseph Pizzino, a mafia soldier, claimed responsibility to me for the execution in an attempt to thwart my investigation of his alleged embezzlement of my father's U.S. savings bonds in '72. I was also harassed on other occasions by my uncle and his mob associates, as my father was before me. My mother used my Uncle Joe to keep my father in line. During a telephonic conversation I had with Assistant U.S. Attorney Richard D. Kaufman on October 27, 2007, who I'd corresponded with since 1985, Kaufman states, quote, "Obviously the FBI is dropping the ball," unquote, on the Thomas F. Martin murder investigation involving organized crime. See link to telephonic recording below. I litigated the SSA case from 1992 to 2001 pro se as party in interest and as proper party estate delegate, winning 2 consecutive appeals at the Second Circuit to recover over $100,000. I then filed a writ of certiorari at the U.S. Supreme Court for pro se legal work compensation. The case was rejected. The SSA inconceivably argued all along my father's '76 application was filed incorrectly, yet refused to produce it to this day. No attorney in Western New York was willing to represent me. Several declared so in writing, which I entered into the record, with one informing me confidentially if she were to represent me, her livelihood would be in jeopardy. The 1976 was deemed filed correctly a few weeks prior to oral argument on my second appeal at the U.S. Court of Appeals Second Circuit. I just might have another shot for compensation for my pro se legal work. I'd be the first pro se in U.S. history to get paid as the prevailing party against a government agency, thus overturning the U.S. Supreme Court case of K versus Erler, 499 U.S. Reports, page 432, 1991. Mr. Joseph F. Krangle, Esquire, court examiner, via his order to show cause on December 4th, 2003, petitioned for the final accounting and discharge of the successor coal committee. Krangle had previously telephoned my cousin, Eleanor Iannaccone, as co-committee more than once in an attempt to sway her to file a final accounting to no avail. Krangle stated in his unverified affirmation, my father died without a will. The successor co-committee responded by sworn to affidavit, provided evidence of the 1965 will of my father, and stated the necessity to finalize the investigation for the accounting and recovery of the $1 million investment of U.S. savings bonds. Bettina, acting New York State Supreme Court Justice issued an order of December 24th, 2003, discharging the successor co-committee and deemed the interim accounting that included the recovered $100,000 in SSA funds as final prior to his retirement on January 1st, 2004. As successor co-committee, I filed a timely notice of appeal on January 13th, 2004 to Matina's order of 12/24/03 and motion on February 26, 2004 in the New York State Supreme Court to vacate the order of 12/24/03. A letter of February 26, 04 by the successor co-committee was sent to New York State Attorney General Elliot Spitzer requesting that his office reopen their investigation of the Erie County Surrogate and New York State Supreme Court procedures in this matter involving an incompetence estate. A letter of February 26, 04 by the successor co-committee was sent to New York State Governor George Pataki requesting that he review these criminal matters involving the alleged embezzlement and laundering of federal funds belonging to my father for an appointment of a special prosecutor. On March 29, 04, we received a letter from the New York State Unified Court System stating, quote, "Please be advised that neither Governor Pataki nor the Office of Court Administration can interfere with or otherwise influence the decisions of the courts or judges," unquote. On April 22nd, 04, we received a letter from the Office of the New York State Attorney General stating, quote, "Only the governor, however, has the authority to appoint a special prosecutor. Therefore, if you have not done so already, we suggest that you contact Governor Pataki," unquote. See copies of letters to New York State Attorney General Spitzer and Governor Pataki and the responses at the link below. Richard D. Kaufman, Western New York Assistant U.S. Attorney, was provided information by me relating to these criminal matters since 1985. I provided Kaufman a copy of my letters to the Attorney General and Governor. I spoke to Mr. Kaufman on April 2nd, 2004. Kaufman said that the governor should have reviewed this matter for appointment of a special prosecutor and to keep pushing the Attorney General, Elliot Spitzer, since his office has jurisdiction in this criminal matter. Listen to the telephonic recording of our April 2nd, 2004 conversation below. My elder cousin, Evelyn Jimerson, formerly Harcrow, in an attempt to assist me in my cause for justice before the biased, hostile court, swore in an affidavit filed on March 31st, 2004, in the Surrogate and New York State Supreme Court files, that from her own information and belief, the 1965 wills were made by Musara, and the $1 million in U.S. savings bonds belonging to my father, derived from his VA funds since 1945, were negotiated in 1972 and deposited in my mother's accounts. See link below for the Harcrow affidavit. Surrogate Barbara Howe, the fourth surrogate in these proceedings, held a hearing on April 1st, 2004 as acting New York State Supreme Court Justice on my motion filed February 26, 2004 to vacate the order of 12/24/03 by Matina, dismissing the successor co-committee and deeming the interim accounting as final. I argued under New York State Mental Hygiene Law, Section 81.20, A63, it is the successor co-committee's duty to locate my father's will, and that Harrison, Volume 135, New York Supplement, Second Series, page 247, 1954, provides that, quote, Settlement of the final accounting of the guardian should be delayed even after the death of the incapacitated person, where discovery of and information pertaining to the filing, removal, and location of a will is left unresolved." Unquote. I also argue that under New York State Mental Hygiene Law 81.33, quote, "It is the mandate of the guardian to investigate and report all financial activities of any income during the incompetent's lifetime prior to discharge." Unquote. That would include an accounting of the $1 million investment of U.S. savings bonds that rightfully and legally belonged to my father, derived from his VA disability funds from 1945 to 1972. And I argue that under Surrogate Court Procedure Act 1401, the surrogate must allow for the discovery of my father's will by his family. Incidentally, Barbara Howe was my professor at SUNY at Buffalo, and I attended her criminal justice class prior to my graduation in May 2004. Having replaced Martina, I informed her soon I would be before her bench and provided her a copy of my writ of certiorari from my SSA case as a gift. On April 21st, 2004, Honorable Barbara Howe filed an order as acting Supreme Court Justice, stating in part, quote, "Petitioner, successor, co-committee, having moved this court by notice of motion filed 22604 for an order vacating the judgment and order entered 122403, now upon the affidavits of William G. Iannaccone, Eleanor Iannaccone, and the affidavit of Evelyn Harcrow, sworn to on March 29, 2004, and upon the affirmation of Joseph F. Krangle, Esquire, dated 3/25/04, submitted in opposition of petitioner's motion, it is hereby ordered the petitioner's motion shall be treated as a motion to re-argue and to renew, and it is further ordered. The petitioner's motion is hereby denied, and it is further ordered. The petitioner's subsequent request for rehearing is also denied." Unquote. Signed, Honorable Barbara Howe, Acting Supreme Court Justice, granted 4/21/04. On September 2nd, 04, the appellant successor co-committee filed our notice of motion for stay of the 12/24/03 order by Martina, pending the final accounting with the New York State Supreme Court Appellate Division, 4th Department, and that the incidental subsequent orders of the court below issued on April 21st, 04 be annulled. My motion for stay on appeal was denied. However, this was a ruling solely on the procedural issue by the higher court, thus does not preclude my continuing investigation and recovery of my father's U.S. saving bonds, nor the proving of my father's 1965 will, as I remain the administrator of my father's estate to this present time. My investigations, litigation, finalization of legal projects based upon the overwhelming probative evidence I've discovered and documented are continuing. I intend to obtain a full accounting under oath of all relevant DOT records, including the registration records pertaining to the embezzlement and laundered U.S. savings bonds valued at $1 million belonging to my father, derived from his VA disability funds from 1945 to 72. See the complete procedural history of the Erie County Surrogate New York State Supreme Court record involving the estates of Peter and Mamie Iannaccone below. See the chronology of evidence of the money trail and relevant MK Ultra experimentation conducted on my father and I below. I'm also investigating whether the U.S. military resorted to chemical biological warfare in gene mutation in conjunction with the spraying of the defoliant Agent Orange during the Vietnam War, causing FSH muscular dystrophy in Vietnamese civilians, U.S. soldiers, and my son Sal, allegedly caused by my March 7, 1968 injection by Dr. Smith. Smith was a member of the SUNY at Buffalo Medical School, which was doing research for the Department of Defense in chemical biological warfare at that time of my injection in 1968. Research on Project Themis, a Navy project, was also being conducted at that time. The DoD funding agencies included the Advanced Research Projects Agency, ARPA, the Air Force, and the Army. I've just begun my fight for truth and justice. I'm moving on. Waller says in his epilogue, on Henry Peterson and Robert Peliquin, the two DOJ officers who first launched the strike force idea in 1967, Peterson became involved in serving Nixon's interests during the Watergate cover-up and left the DOJ. Peliquin, as early as 1966, on a DOJ official assignment in the Caribbean, reported overtures by organized crime to take over casino gambling in the Bahamas. Peliquin reported phenomenal success of ridding the casino of mob takeovers. So successful, in fact, he formed his own concern to offer his services so businessmen worried of mafia takeover of their companies. By late 1967, Peliquin resigned from the DOJ and went to work as VP of a company that operated Paradise Island Gambling, a subsidiary of the Mary Carter Paint Company. Eduardo Salini, an aide of mobster Mayor Lansky from the early days of Havana, was manager of the casino under Peliquin. In early 1968, Mary Carter Paint Company changed its name to Resorts International Incorporated. Resorts International built a casino on Paradise Island. Richard Nixon was the guest of honor at the casino's grand opening on New Year's Eve 1968. James Crosby, president of Resorts International, contributed $100,000 to Nixon's campaign. Crosby, B.B. Rebozo, Nixon's buddy, and Nixon partied with a bevy of movie stars, gangsters, and GOP faithful. If you found these facts interesting, I'm sure you'll find my research intriguing. Please join the Iannaccone Family Patreon campaign, linked below, to follow the progress of our movie production, The Awesome Awakening, a true story based on my thesis, The Secret Agenda of MK Ultra, and the finalization of our legal projects for truth and reconciliation. Also, please subscribe to my YouTube channel for my past and latest videos, also linked below. For the complete transcript of this presentation, please see the PDF link below this YouTube video. For easy access to the source links mentioned in this presentation, see those PDF links listed separately, also beneath this YouTube video. Thank you all for listening. I really appreciate your interest. See you again soon.